Continuing debate to the Honourable Member for Elgin, Middlesex, London.
Thank you very much, Mr. Speaker, and it is truly an honour to stand here as we're discussing business supply and the main estimates for 2023. And I would like to begin by thanking a lot of people over the last 3 weeks who have been talking to me about the Supreme Court ruling that was made on May 13th. I would like to thank the member who just spoke honourably earlier, the Honourable Member representing New Brunswick. I would like to thank people from the London Abused Women's Centre, especially Jennifer Dunn and Megan Walker, and all those who have connected with me to say, is this really the truth? Is this really the sense of this, what's happening? And I want to go to what's happened as of May 13th and the discussions that started following a Supreme Court ruling decision. On May the 13th, the Supreme Court of Canada issued a major decision indicating that criminal defences in cases involving assault, including sexual assault, that they'd be able to use a defense known as a self-induced extreme intoxication. Now, for me, it's really hard to look at this. I'm not a lawyer. I'm just a normal human being who has children, who has family, and who loves my community. And I want to ensure that things like this don't actually exist in the court of law. And the problem that I'm finding is when I do reach out to some of these lawyers, when I've reached out to some of these Crown attorneys, and two of the amazing support that we have here from Brant Brantford, and also from Caribou, just the work that they have done to share with me what's going on here. And I think these are the things we need to talk about. So I'm not just going to blither anymore. I'm going to talk about what's actually happened. So on that date, there was a ruling saying that extreme intoxication could be used because it goes against the Charter of Rights, Section 7 and 11. And so I started looking at this saying, what does this actually mean and how does this happen? And I go back to the history of why in the Criminal Code 33.1 exists in the first place. And this had to do with the fact that someone had been charged and there was a problem because at the end of the day, they were allowed to use this type of defense, the fact that they were totally intoxicated, yet this person had sexually assaulted somebody. So I started looking at some of the different cases on this and seeing why is this such an important thing to Canada and how can we ensure that this will never happen again? How can we ensure that somebody will never be able to use extreme intoxication, especially when it's an offense on another individual, especially when it's to do with sexual assault, bodily harm, any types of violence where it's actually going against a different person. And this is why I'm so concerned with this, Mr. Speaker. When the Supreme Court ruling came out, I asked to my colleagues 3 key issues. What needs to be addressed in the criminal code? What are the specific loopholes? And what can we do to address this issue immediately? So the first thing that we did as a group, and there was 4 of us that signed on, we sent a letter to the Minister. We sent a letter to the Minister and the Attorney General of Canada explaining to him, we are here, we want to talk about this, but we know that there's an issue. And in our letter, we indicated these decisions imperil the safety of sexual assault victims by permitting the dubious defense of non-insane automatism due to self-induced intoxication. Sexual offenses disproportionately affect women and vulnerable people. The Attorney General has had sufficient time to study this ruling. The ruling clearly implores the government to act. The government has not. However, we've only heard silence from this government. And that's why I'm coming here today to you, sir, because this judgment was made on May the 13th. Today is June the 7th. We already know that when it comes to victims of sexual abuse and exploitation, that the chances of them coming forward are already very, very slim. And if you're going into a criminal justice system where we just finished Bill C-233 last week where we talked about judges training and we talked about the fact that there is such a disconnect here that, understanding domestic violence, understanding criminal law, all of these things, understanding what it's like to be a victim is so, so important. And that's why I will continue to ask and to continue to advocate on judges actually having training on domestic abuse, on sexual exploitation, on rape, all of these things, how important it is. And although Bill C-233, we expect it to pass through the Senate, we still need to make sure that these judges are taking this. And this is when we look at this decision just going, oh my gosh, the victim is lost throughout the entire discussion here. And that is why I have so many issues with this. So this is a letter that we have sent, and this letter was sent over 2 weeks ago. We are still waiting for a response. I recognize that the minister has spoken to us in question period, but we're waiting for action. And that is what I'm calling about today. We want action. We have people like Jennifer Dunn, the Executive Director of the London Abused Women's Centre, and I quote, "Women are already disproportionately affected when it comes to assault and sexual assault, so this will affect them tenfold," said Dunn. "To be able to use them that as an excuse and potentially not be convicted of their crimes is absolutely absurd. And that's why I want to continue to have this discussion, because we're talking about, you know, a person, and the fact that if they're violated, there is a fear that if they come forward after everything, whether it's the judge's training, whether it's, you know, whatever it may be, but the fact that they could even use extreme intoxication as a defense, I'm sorry. If that was my daughter who was raped and someone used extreme intoxication, sir, I just, as a mother, as watching my child, how could you let this happen? And so I ask every person out there, let's reflect on, if this is a member of your family, if this was a member of your community, how would you feel if you knew that you did nothing? It's been 3 weeks now. Let's get this done. So I'm just going to ask the minister to let's get this done. We know that Section 33(1) is unconstitutional based on the 9 Supreme Court judges saying that was unconstitutional. And they have come back to this government and they indicated even in their decision that the government could do something. So I'm asking, where is the government on this? Why haven't you done anything? I know that on an issue just a month ago, they had an immediate response. The moment they were talking about oil and gas, that day they talked about the fact that they were going to appeal that decision. Well, we are talking 3 weeks later, and we still have not heard from this government what they're planning on doing. And I want to go back and talk about why 33(1) was put there in the first place, so that you have an idea of what can happen and why this is so important. So as I'm looking through these notes, there were cases that are involving, here's one, 2 cases involved men who were high on drugs when they killed and injured family members. The extreme intoxication was used to acquit one man and ordered a new trial for one. So just right there, we have high on drugs and killed and injured family members. Now, the case that just came up here recently, I know that there's been lots of discussion on that one, and you know, it's not up to me as a parliamentarian to judge what's right and wrong, but it is to fill in those holes when we sit there and say, but is this fair? And this is where the rights of the victim are lost. And the rights of the criminals, they talk about, well, you know, it's their charter rights. Charters, it's Section 7 and 11, it's their charter rights. Well, I ask you, if you are a person who has been violated, every single right has been gone because your violator took those away from you. They took away your rights. And all of us, and all we're worrying about are the rights. And this is where I sit there and think the criminal rights are outweighing the victim's rights. Something is absolutely so wrong there. The case that brought this all up and to do, and the reason we're having this discussion was because of the May 13th decision that was a case in which a man involved who was consumed alcohol and magic mushrooms, and they broke into a home of a female victim and violently assaulted her with a broom handle, leaving permanent injuries. He was declared by the courts in a psychotic state and had no will to control over his actions. And so, Madam Speaker, it's wonderful to see you there, but I sit here and I think, extreme intoxication, how do we define extreme intoxication? How many times do you go onto somebody's Facebook and say, someone wrote, I was extremely intoxicated? You know, I've spoken to friends, I've spoken to different people who will talk about not remembering what happened that night. But what we're doing here is we're actually saying that if you are not able to make that choice, then although you voluntarily consume the alcohol or the drugs, you're involuntarily doing the thing because you do not have that state of mind to make the right judgment. I go back to point 1. You had that choice to drink. You had that choice to take drugs. There are cases, don't get me wrong, there are cases. Let's think about some awful things that have happened where people have been given drugs. We understand that this happens as well. So, you know, we got to look at that. But when somebody is voluntarily doing something, and then at the next time they're actually victimizing somebody else, why are we sitting back and allowing that to be the case? Why are we sitting there saying extreme intoxication could be used? We know that it's very minute because we know that there's a threshold. But my problem, Madam Speaker, is that 1 is too many. That could be your daughter. That could be somebody's daughter. That could be anything like this. We have to look at the victims first. We have to look at the violators first. And that's what we're not doing. I think that the decision made by the Supreme Court, whether it's right and wrong, they gave direction to this government to do something. And I'm asking this government, where are you? Where are you at making this decision? We know that, as I said, people are not going to come forward if they think that this will be able to be used. And so I'm very, very concerned as we're moving forward. There's a lot of work that we need to do here, Madam Speaker. There's a lot of work that I believe when it comes to intimate partner violence, when it comes to violence, when it comes to offenses on other victims, that we can all agree that the victims matter and that they should come first. And so I urge this government to do something now, not 3 weeks from now, but now. Thank you very much, Madam Speaker.
Questions and comments? Questions et commentaires? The Honourable Member for Victoria.
And I want to thank the member for her speech and for raising this really important issue. The member had mentioned that this happened 3 weeks ago, but the Ontario court actually ruled on this 2 years ago. And 2 years ago this week, my colleague, my New Democrat colleague, the member from London, Fanshawe, called on this government to explore changes to the law to ensure that extreme intoxication could not be used as a defense. It's been 2 years since we've been calling for this government to explore those changes. I wonder if the member can comment about this. It is just so unacceptable that this government is delaying and delaying, and that victims are paying the price.
For Elgin, Middlesex, London.
Well, thank you very much for that question. I think she wrapped it up perfectly there. The government is late. They're late to the game. Victims need to come first. And we have seen that when we're talking about the Victims' Bill of Rights, when we're talking about the Victims' Ombudsman. Where are they? I really appreciate the fact that the member from London, Fanshawe, I know that she works on issues doing with women all the time. And I will stand beside her as she's working for these issues. Because I think that when we see that women are violated, that we do stand together on these issues. So thank you very much for this question. And let's work together to get this government to do something.
The Honourable Member for Saanich Gulf Islands.
Thank you, Madam Speaker. And again, pursuing the point that the Honourable Member for Elgin Middlesex had put forward, I was very troubled by the Supreme Court of Canada decision when it came down. And the more I read about it, the more I see that and read the decision, the court carefully differentiated mere drunkenness from this very specific extreme intoxication defense. It doesn't mean I'm satisfied that we leave the law as it is. We obviously cannot appeal this decision. It's a Supreme Court of Canada decision. But I do agree with the member for Victoria and the honourable member for Essex Middlesex. I'm afraid I'm getting the wrong riding name. I'm very embarrassed, but I know her so well, and she's great. But what I would suggest is that we could all work together across party lines, recognizing that the Supreme Court of Canada itself has invited Parliament to legislate in this area in ways that would not offend the Charter, to make sure that even in extreme intoxication cases, there was not a loophole for violent crime.
Oh, Member for Elgin, Middlesex, London.
And there you go. Saanich Gulf Islands, Elgin, Middlesex, London, greatest place to be. As we all say, we all love our ridings. And I do understand where she's coming from, because it's that line on what we call, where does the extreme intoxication start? When does drunkenness start and extreme intoxication become that? And that is the line that we have to figure out. Right now, there is no true definition. We know that there needs to be psychologists and psychiatrists and a variety of different people. So we know that threshold is high, but there needs to be something more defined. So at this time, Supreme Court of Canada has come back and said, legislators and members of Parliament need to fix this. So that is our job. We should be having these discussions and fixing it. Thank you.
Questions and comments? The Honourable Member for Kelowna Lake Country.
Thank you, Madam Speaker, and I want to thank my colleague for her great speech and intervention, and for her strong advocacy ongoing for victims. I'm wondering if you can comment just on this government's overarching theme to be soft on crime. We see it in a number of ways with different legislation that they bring forth, and in just how they seem to approach many different issues. So I'm wondering if you can maybe comment on just the way that they approach not really standing up for victims of crime, and just this real soft on crime approach that they have.
Just as a reminder, it's the Honourable Member who's going to comment, not myself. The Honourable Member for Elgin, Middlesex, London.
Thank you very much. And to that point right there, you know, soft on crime is exactly where I see this. We talk about the revolving door that we see in the courts. We talk about that all the time, and we continue to see that. That is because there's loophole after loophole after loophole. And that is where the government, when it comes to criminal law, when it comes to laws like this, that we need to look at that and say, where does the victim fit in here? I've had my time watching different court sessions, and I recognize that at the end of the day, we have this government that's coming out with, you know, let's get rid of mandatory minimum sentence, let's do this, let's do that. I want to know how many actually victims organizations are sitting at the table when they're talking about this. I've sat with people who have gone to some of these parole board hearings and have had to be once again re-victimized after the loss of a sister. I've spoken to these people. And so I ask the government, stand in their shoes for one day. Imagine what it's like to lose a loved one. And then imagine that they're having to stand to a government who sits there and soft on crime. So thank you very much for that question.